Welcome. My name is Danielle Vinay, and I will discuss the general divorce process, child custody, considerations for evaluation, child custody arrangements, and with the code of ethics, considerations, and tips for releasing information when subpoenaed. I will now discuss the general divorce process. The first step in this process is one member of the couple filing a petition for a divorce. Even if both parties agree on a divorce, one of the parties will have to file the petition with the court to divorce. The petition will include the grounds for divorce. In the state of Georgia, the couple will have to be a resident for a total of 6 months in order to file a divorce. I will be discussing the Georgia laws because I am a resident of Georgia. In Georgia, if the couple meets the requirements to file a divorce, they would do so at the Superior Court in the county in which they reside. The most simple type of divorce would be a uncontested divorce, where both parties agree on all issues. If the divorce is uncontested, both parties will have to come up with an agreement on financial support and custody. The next step of the divorce process is the response from the other party. The party who receives service of process will then need to file a response to the petition. And if the divorce was filed on fault grounds and the responding party has a dispute for those grounds, he or she will need to address it with a response. If the party has a disagreement, it should be set out in the response. The next step in the divorce process will be the negotiation phase. The parties will have to negotiate their differences, and if the parties disagree, the court may schedule settlement conferences that attempt to move the parties toward a resolution. The next phase in the trial, any issues the parties absolutely cannot resolve between themselves will have to be decided at a trial. The last phase of divorce is the order of dissolution, which ends the marriage and sort out finances, custody, support, and any other issues. The next topic that I will discuss will be child custody. The first step in the child custody is the parents reaching a negotiation on custody. If parents are able to come to a resolution on child custody arrangements, that arrangement will be put in writing and filed within the petition. If parents are unable to come to a custody arrangement, the court will likely have to be involved, generally a family court judge, to make a decision on the child custody and visitation. In the state of Georgia, the judge will make the custody determination and determine how the child's time will be divided between both parents and how decisions will be made about the child's welfare. Another requirement in the state of Georgia is the requirement of a parenting plan. Both parties will have to submit a parenting plan to the courts, the judge, to determine how the child will spend their time with each party, as well as discuss any financial custody arrangements that both parties have. I will now discuss considerations for evaluating child custody arrangements. When considering evaluating parents for child custody arrangements, the therapist should thoroughly determine the welfare of the child and the psychological state of the parents. The therapist should have the child's best interests, and in doing so, should review both parties' parenting plan and access caretaking abilities. In this process, it is important for MFTs to be aware of their own biases and those of others. Biases are likely to interfere with considerations of evaluating child custody. Therapists must strive for accurate methods for addressing the questions raised in a specific child custody evaluation. Evaluations most likely will entail clinical interview and behavioral observations by both parents. Therapists may also gather information from schools, healthcare providers, child care providers, agencies, and other institutions, and frequently make contact with members of the extended family and any other collateral sources when resulting information. Doing so will allow the therapist to gather a consensus of the best interest of the child. The therapist decides to make a child custody recommendation within the court. Their recommendation should be contrived data from their evaluations and address the psychological best interests of the child. When making a recommendation, therapists seek to avoid relying upon personal bias or unsupported beliefs. However, the therapist should contrive that data from the sources in which therapists should rely on their testing, behavioral observations, and conversations with the agencies in which they interviewed, and that should be the basis of their recommendation. I will discuss the Empathy Code of Ethics considerations. In the Code of Ethics, Section 1.8, Client Autonomy and Decision Making, it discusses divorce. I'll read that. Marriage and family therapists respect the rights of clients to make decisions and to help them understand the consequences of these decisions. Therapists clearly advise clients that clients have the responsibility to make decisions regarding relationships such as cohabitation, marriage, divorce, separation, reconciliation, custody, and visitation. The Code of Ethics gives clear guidance as to how MFTs must proceed in assisting parties that are going through divorce. I will discuss the Georgia Code of Ethics and how it relates to couples that's divorcing. A MFT's responsibility is to the client. The therapist should make every reasonable effort to promote the welfare, autonomy, and best interests of their client, respecting the rights of those persons, seeking assistance, attaining informed consent, and making reasonable efforts to ensure that the therapist services are used appropriately. I will discuss tips for releasing information when subpoenaed. If the therapist is subpoenaed, the court deemed it necessary for the therapist to provide information related to the divorce. If the therapist is subpoenaed, the therapist must respond to the subpoena at a specific place and time. Responding to the subpoena does not mean that the therapist releases confidential information about the couple. Before the therapist responds, he or she must ensure that the subpoena is valid and that the conditions for disclosing confidential information are met, such as client's consent, a protective order, or other legal mandate. In contrast, if the therapist does not respond to the subpoena, he or she will be held in contempt with the court if they fail to comply with the court order. The first step in dealing with a subpoena is to determine whether the request for information carries the force of law. The second step is contacting the clients. The third step is to negotiate with the requester. If a client decides not to consent to the released information, the therapist may seek to prevent disclosure through discussions with legal counsel through the requested party. Some rules often allow the therapist to assert privilege on behalf of the client in absence of a specified release or court order. Therapists often have to determine if there are ways to achieve the requesting party's objectives without divulging any confidential information. If the therapist is asked to discuss confidential information during questioning at a disposition, he or she may refuse to answer the questions only if the information is privileged. A therapist may also refuse to provide client records by asserting a privilege if it's considered reasonable basis. Therapists who refuse to answer questions without a reasonable basis may be penalized by the court. It is also advisable for the therapist to be represented by his or her own counsel at the time of disposition. I've discussed the general divorce process, child custody, considerations for evaluation regarding child custody arrangements, the Code of Ethic considerations, and tips for releasing information when subpoenaed. I would like to open the floor now for any questions. Thank you for your time.